We're going to have a short hearing on the Cornell and Rogers case. This is D 2021-64185. It looks like we have Anton Cornell connected by Blue Jeans. Are you there, sir?
Yes, sir.
And we have Rogers also connected?
Yep.
We had a hearing yesterday also on this case, but Mom appeared, Dad did not appear, so we left it on calendar today. I'm glad that Dad's here. This is the time set for the return from the mediation referral. Now, the court received or made an order for a mediation referral. I received a partial agreement from the Mediation Center. That partial agreement says that the parents weren't able to reach an agreement regarding the timeshare and transportation. They have a jointly custody agreement, they have holidays and vacations, and I need to get confirmation that we can file this partial agreement. Now, back on June 9th, the court issued a temporary order stating that the mom and dad would have visitation on June 2nd and June 13th. Did you have that visitation, sir?
No, sir.
So you didn't have visitation on Saturday and Sunday, the 12th and 13th of June?
Oh, yes, sir. Yeah, excuse me. Yes, sir. That was the first 24 hours you ordered.
All right. And then we said that you would have visitation on the weekends except for the first weekend of the month, and that would be Friday until Monday. Did you have that visitation since June 7th?
No, sir.
At all? No visitation?
At all, sir.
Okay. Now, so do you have any objection to the filing of the partial parenting agreement that was submitted to the court? I mean, it sounds like, we got all this noise in the background. Just sit quietly, and so we don't have the back. I have to be able to hear you guys.
Yes, sir. That's not me, sir. I'm just relaxing.
All right, Mr. Cornell, please just tell me whether you have any objection to the partial agreement being filed.
Let me understand what you mean the partial agreement that you set for us in the beginning?
No, the partial agreement doesn't resolve everything. If you were here in court, like we're supposed to have court, I would basically give it to you to sign, give it to Mom to sign, and we would file it. I just need to make sure that you don't object to the partial parenting agreement that you reached in mediation getting filed.
Absolutely not, sir. I understand what you're saying now. I'm sorry.
All right, so let me visit with Ms. Rogers. Ms. Rogers.
Yes.
It sounds like Dad, the court issued an order in June saying that Dad would have visitation on the 12th and 13th, and it sounds like he got that. But that he was supposed to get visits every weekend but the first weekend of the month, and he says he didn't get any of that. What happened?
Well, that isn't true, sir. He did miss the 2 weekends after that, which is the contempt of court, which he did file. I filed my response to that. After that, he did get my son, and he has been over in his presence. So the one other week that he did miss was this last 3rd week of the month, just because I felt like there was too much going on with the whole TPO and everything, and I really didn't feel safe with him being over there, and I have some concerns with him being there, so he didn't go this past 3rd weekend.
I haven't heard the evidence on this, but generally speaking, it's not a good idea to violate the orders because it'll be your responsibility to show that that decision is somehow justified. The fact is that I am aware of the protective order stuff. I see that there's another hearing that's scheduled for August 23rd in a protective order case.
Right.
You need to follow the custodial orders. The court is going to file the partial parenting agreement. We need a trial, I guess, or some sort of way to resolve the dispute concerning the weekly timeshare, but the temporary order has to get followed. Now, the protective order, if a protective order is entered, is going to include the visitation provisions. And we said that the exchanges would take place at a learning center on Flamingo and Durango. Is that where you did that?
that's where they were taking place. We did make arrangements. I had someone drop him off and meet him at a local CVS by my house. And I've had my daughter pick him up before from him. So he's no longer at that facility. So,
all right, so we need to pick another place to exchange. Now, Mr. Cornell, I asked you to prepare the order from the hearing on June 9th, but you haven't done that.
Yes, sir, I have done that. I have the papers here. I've done that, and what they did was, once I guess that was the hearing was set for yesterday, and I missed that hearing, and I deeply apologize for that. But as soon as you told me to prepare the order, so therefore she cannot take my son out of state, I did it the next following day.
Well, there is no order that she can't take the child out of state. She can't move out of state, but let me look in the file. I don't see a notation that shows that the order has been filed. If it hasn't been filed, you need to submit it. It's no good in your hands if it hasn't been filed, okay?
Okay.
I'm in your case, and I'm looking at it, and it shows that there was a hearing on the 9th, and there's no order entered, okay? So submit the order to the Department H inbox so that it can be filed. Where would you like to exchange the child on Fridays and Mondays if the child is no longer going to this Infinity Learning Center?
Sir, I would just have to, real quick, I have, now I had in this whole mediation, I had requested if we could change these dates. So I don't even know if that is an item up for discussion or not.
Well, that's an item that would be a trial issue, and I can set this matter for you and Dad to testify about it, but I don't know, that mediation's confidential, so I don't know what you're asking to change. What is the schedule? What is the schedule that you think is best for the child?
First of all, I just want to say, like, this man hasn't been involved in this boy's life for over a year, and for him to just be like, here, freely, here's your son for 3 weeks. Granted, yes, he is his son. However, he's got alcohol issues. He's got stability issues. He doesn't work. I have concerns with him being in his presence. And coming from a mom that I've cared for this boy for over 4 years, and seeing that this man, his previous relationship with his daughter, he doesn't have custody of his daughter. Like, there's so many things that have gone on that raise concerns. And then there hasn't been like, okay, this is what's going to happen little by little. It was like, no, bam, here's your kid. Mom, it doesn't matter what's going on, what this man's done to you or is done in the past. Here's his kid. Like, that concerns me majorly, and I'm not okay with that.
Okay,
I'm not okay with that.
The parenting agreement that you reached in mediation provides in part that you would alternate spring break.
Right, and that...
I know, but listen,
and that,
this is not a time to talk. Please listen.
I'm listening.
You agreed that the child would be with you in odd-numbered years and with Dad in even-numbered years. Spring break is 9 days in duration, from the day school is out until the day school resumes. When I see that type of provision, the winter break provision, the spring break provision, I don't understand where you're coming from when you say that you have concerns about Dad having 3 weekends a month. Because you just agreed that he would have 10 days in a row in spring every other year, and part of winter break in the other. So,
right, and that I actually didn't even sign because he actually broke the TPO order after that, and I just don't see that that's right, that he could get my son, our son, for this duration of time when he has these certain issues and certain things that aren't resolved with him in order for him to be...
So the mediation specialist is wrong? The mediation specialist
She's not wrong.
She sent a letter to the court saying the parties did not resolve everything, but they resolved these issues in the partial parenting agreement, and the signature pages will be approved at court. So is the mediation specialist wrong?
No, she is not wrong.
So
we did discuss that, and at that time, because...
Why did you tell me that the partial agreement, that you don't approve it now?
Because he broke the TP order. I have concerns on his behavior. Well, it's not like I woke up and said, oh, let me just say this. No, like, I have major concerns.
Well,
I was trying to give him the benefit of the doubt, give him his timeshare, and that was too under the impression we would be granted the permission to leave state. And so, you know what? Within that time, there's going to be time to resolve things, time to work, time to take classes. But no, he went and broke the TPO after that, and I didn't feel comfortable with signing that.
Then I won't file it. But I just asked you a simple question. Is
Yes.
the partial parenting agreement acceptable or not? The specialist
No.
said that you approved it. If it's not acceptable, then I'll order it at another time. I won't file it.
All right.
I'll make
That's
it part of
fine.
the trial. I'm telling you,
Okay.
you want primary custody, correct?
Yes.
All right, and you believe that it's best for the child that you have primary responsibility.
I do.
Well, if you want the court to agree with you and find that that's best, you have to be reliable in following the court orders that make sure that the visitation that the other parent has is followed. Okay?
So regardless of who he is, if it's too late that he harms my kid, if it's too late that he does something to me, it's okay because you, the court, say he's supposed to go over there. He came back with bruises. I don't even know who the kid he's around. Said the kid's been punching him. I don't even know where he's at. He's not at his home. He's with his girlfriend who doesn't even trust him to be around her own kids. I have major concerns for this. And as a mom, I'm okay with sharing, but he needs to show some improvement in himself, show that he's stable to take care of this boy. Do parenting classes, communication classes, his domestic violence, alcohol classes. I'm not against sharing him. There's just things that he needs to work on in order to be a better parent.
Okay, well, the court has heard no evidence in this case. The case was filed in March, and the answer to counterclaim was in May. The filings by you have been very, I mean, I don't know if you've even filed anything. You filed a response in opposition. Oh, wait a minute. You filed a motion on May 4th, and in that motion, it's an 8-page form that you filled out. You wrote like 2 sentences. First, you said, "My son doesn't know him as his father." Okay? Well, that's not true.
Mm-hmm.
And you said that. Let's see. You say that he continues to drink, and I can't really read the other stuff. Anyway, you talk about your job more than that, and then you said that. I mean, you basically are filing a request to remove the child. You're not going to have permission to move the child from the state unless there is an alternate plan that will be followed. In other words, you may have a sensible reason to move. But if you have a sensible reason to move, it's got to come with a parenting plan that will allow dad to maintain a relationship with the child. And if you have a track record of deciding when you want to follow the court orders, you're not going to get permission to move. Okay? So you need to follow the court orders. If dad is engaged in behavior that neglects the child or is a threat to you or the child, the court will do something about it. But just alleging it in general without evidence is not going to result in restricting those times. Okay? So I know that I'm just trying to tell you that of course your concerns are relevant. But if you are expecting the court to essentially act on those concerns without detail and without evidence, you're going to be disappointed because the court has policy that it must follow, which is separated parents need to be given an opportunity to have a meaningful relationship with the child. And if dad seeks a relationship with the child, and he filed this case, if dad has a place and the ability to care for the child, the court has to support a visitation order. And right now, the temporary order is mom having primary custody subject to dad's visits on basically 3 weekends out of the calendar month from Friday night to Monday night. That should be followed until the court can hear evidence in the case. Now, I don't have a handle on the TPO stuff. I mean, obviously, it's a big concern that we have these protective order cases. I read the cases that were filed back in 2016 and 17 and 18. Now, there is a protective order case, and I don't know why it's not listed as a related case, but we tracked it down, and there is a 2021 case that was, that's pending, and the court will let that process take place. But whatever that order is concerning the protective order, they're going to follow the district court's orders related to visitation. There was a hearing on July 7th, and Dad was not present. You were present, and the master recommended the custody and visitation order to be followed in this case, which is appropriate. And then you filed a request for some sort of relief. There's a order denying that request ex parte, but setting the matter for hearing on August 23rd, 2011. Mr. Rogers, did you know anything about this?
There's no Mr. Rogers here.
I mean, not Mr. Rogers.
It's Cornell.
I mean, Mr. Cornell, did you know anything about this? Well, he's the defendant in that case.
What's that, sir?
You know about the hearing on August 23rd?
No, sir. I don't know what that's about.
All right. Well, there's a protective order that was entered or heard back at the beginning of July, and there's an affidavit stating that you were served with the papers on July 16th at 7100 West Alexander, number 2110. Okay. So I have a
Yes, sir.
I have a proof here from a guy named Jeff Bergstrom, who I think is a constable or something, who served you with papers. Did you go to court?
I have it right here, Your Honor.
Well, okay, there's a court proceeding, okay? There's a court proceeding on a TPO allegation alleging that you're violating the court order. I'm gonna, look, you guys didn't exchange. What's this nonsense about a CVS? The exchanges are supposed to be at the Infinity Learning Center. Where are the exchanges gonna take place, ma'am?
It's going to have to be at that CVS. I don't have transportation anymore, and so I had to disenroll him out of there because it's not close to my house.
What's the CVS's cross streets?
Durango and West Charleston.
Okay. Sir, do you know where that is?
Yes, sir, Your Honor.
Picked him up there, yeah.
All right. And who did you send with the child, ma'am? Who do you use to help you with that?
I had used a friend, but she's no longer. She's not around anymore.
Okay.
I don't even know how I'm gonna have to how I'm gonna exchange him.
Well, you're gonna. I mean, look. These are the details that separated parents have to figure out. Okay.
Oh, I get that. I understand completely. I mean, that's not saying like, oh, I'm not going to do it or whatnot. I completely understand. It's not my first rodeo.
All right. Well,
I will be sure that he's there, but for it to be the second, third, and fourth weekend, that's still going to be a go? We can't make an adjustment to that?
Not on just a request without an agreement. I need to set a hearing in which you appear and testify and provide evidence to the court that would support that. You want...
Okay, we'll do.
Yeah, and he has filed his case, we haven't even talked about his case, he wants joint physical custody. He wants a split week schedule for joint physical custody. So he may not even be satisfied with these 3 weekends per month. So both of you need to testify and provide evidence that would support your requests, okay? And
you got it.
And the court is basically telling both of you that, well, let me just put it as simply as I can. I sent you to mediation and made a temporary order, the court did, so that you would have some order to how you would operate your custody over the short term. You participated in mediation, which is great. The mediation specialist sent me a partial parenting plan saying they worked out most holidays, but they couldn't work out everything. And we were supposed to file that today. Well, I'm not going to file it if either one of you object. And Mom said at this time she doesn't want the partial agreement to be filed, so I'm not going to file it. But before this case is ended, the court's going to order holidays, and I'll be asking you again what type of holiday schedule to have. at this hearing or the trial, you're going to be making your request for a physical custody schedule or an order. And ma'am, you've asked, you still want to move out of state with the child, right?
Correct.
Yeah, well, when you research what you need to prove in order to do it, the court has to find that you have a sensible reason to go and you're not doing it to defeat dad's rights. That there's an advantage to you, a benefit to you, and that it's in the best interest of the child to move. And that there's an alternate custody schedule that's workable. We can't even get through 6 weeks of you making sure that he gets the child on his weekends. Okay? So that's got to change. All right, so the court is going to set this matter for trial, in which you either appear in person or you appear by Blue Jeans connection. Right now, I just have audio with you two. It's going to be the 23rd of September, about 5 weeks from now, at 1:30. Okay, and you both will appear, and you will tell the court what you think is best for the child as far as custody. But the court is going to expect that you follow the order from the June 9th hearing. Mr. Cornell, I've directed you to prepare an order. You need to prepare an order. If you don't have an order on file, then the court can't enforce it the way that I would if I had a written order. The provision of the order that had the exchanges at the Infinity Learning Center on Flamingo and Durango are going to be modified out of necessity, and the exchange will take place at the CVS on Durango and, was it West Charleston?
Yes.
And those exchanges will take place on Friday at 5 and Monday at 5. And you're going to tell me at the trial whether or not those orders were followed. The court expects to hear from both of you with your testimony. And Ms. Rogers, this would be the chance, and this is not a 5 or 10 minute hearing. This would be a chance for you to tell the court what you want and to give details about why you think that would be in the best interest of your child, okay?
Understood.
All right, and Mr. Cornell, that would be the time for you to appear and offer your testimony as to what you think is best for the child and what you're requesting. All right?
Yes, sir.
So, the trial on the complaint and the counterclaim will be set for the 23rd of September at 1:30. We'll spend 2 hours together if we need to. The court will make an order granting a custody decree after that hearing. And that would be the time, Ms. Rogers, where you would give us the detail of where you want to go, why you want to go, what the advantages are to you and to the child. And the custody schedule that we have now is not doable if you're living far away. We would have to change the custody schedule to, if you were allowed to go, to be larger blocks of time around school breaks, because this child is going to be a school-age child in December.
Yeah, and that was
5 years old, right?
Right.
Yeah.
Yeah, and the mediation, those custody arrangements was in with knowing in case we did leave state and that they would conflict with his school schedule. That they wouldn't conflict.
That's why you have spring break and winter break and those things in there, right? I get it.
Yeah.
But,
yeah.
So I gotta let you go, but I'm glad. Look, it was no big deal, Mr. Cornell, that you weren't appearing yesterday. We want to make sure if you had appeared yesterday, we would have had this discussion and we would have vacated today. And unfortunately, Ms. Rogers appeared both days, and so you need to really pay attention to when the court dates are and make sure you make them. The next court date is September 23rd at 1:30. Okay?
Real quick, Your Honor. So in this joint preliminary injunction, when it says that we're not supposed, the rule 5.518, and we're not supposed to harass the other party, so is that something that I can bring up in the trial as well, or is that not even relevant?
You're going to be able to talk to the court about any concerns you have about the behavior of the other parent.
All right.
So
and by then, and if he doesn't appear,
yeah, I can see.
If he doesn't,
that you have had a relationship together for 5 years or more.
Yeah.
Protective orders from 2016, 2017, 2018, and now 2021. You're going to be able to talk about the history of your relationship.
Okay. Now, if he might have to serve jail time, is that hearing date still going to go on?
Well, I don't know. I mean, we'll see. I'm expecting you guys to be here or be available.
No, I'm saying I'll be there with those on. I already got my paperwork in order, but I'm just saying if he doesn't appear on September 23rd at 1:30, what's to happen?
Well, he can appear by video or in person, and if he can't appear, it depends on why he can't appear.
We just lost my head.
All right. No, you don't have to bring it back. We're done for the hearing. I got to move on to another case. Just be ready to go on the 23rd. Thank you.
I'm ready. We could go today. I'm ready.
We're off the record, ma'am. You can go ahead and hit the red button at the top of your screen to disconnect. Thank you.